matter. Did you wish to reserve any time for rebuttal, counsel?
I would like 5 minutes, please, Your Honor.
Okay, and I will try to time my interruption to advise you that as diplomatically as I can.
Thank you.
You may proceed.
May it please the court, my name is Brad Kelsky and I represent the appellant/plaintiff Sean Pitcher. Appellant requests the court to reverse the trial court's order granting summary judgment in favor of appellee because there are genuine issues of material fact in the record that would preclude the entry of summary judgment. This case is a fact-based inquiry that differs from other apparent agency cases because of the level of involvement and ratification of the agent's conduct as the appellee, Gilley's Custom Homes, specifically participated in the Pitcher Concrete Driveway project that Gilley's Custom Homes seeks to separate itself from in the litigation. In other words, it is appellant's position that the record in this instance is replete with genuine issues of material fact, such that the trial court necessarily weighed the evidence, which is impermissible under the new summary judgment standard that mirrors the federal analysis. Based upon the briefs, both parties agree that the court reviews this matter on a de novo basis. Appellant understands and agrees that Florida jurisprudence establishes that while the subjective understanding of Mr. Pitcher cannot establish apparent agency, there are significant objective acts of the principal, Gilley's Custom Homes, that a reasonable jury could determine that establish all of the elements of apparent agency. As the court is aware—
Mr. Kelsey, can I interrupt you? I want you to at least respond, because I know we're now dealing with the new standard on the motion for summary judgment, not like the old standard where any type of— I want you to address that briefly in terms of the court reviewed all of that, came to the conclusion that even if you provided all this information to the jury, there's really no issue there in terms of, an agency type of relationship. I want you to address that under the new, because a lot of people sometimes conflate the old standard with the new standard. And I know you recognize a new standard, but I want to give you the opportunity to address that.
Yes, Your Honor. The new standard basically says, from our standpoint, that the material facts have to be genuine and material. So they have to basically establish on a factual basis the elements of the cause of action sufficient for a reasonable jury to find in favor of the non-moving party. That would be my response as to what the federal standard adopted by essentially the Florida Supreme Court has agreed with and decided. And we believe in this instance, based upon the three elements of apparent agency, none of which appears to be in dispute between the parties, that there be a representation of the principal, reliance on the representation by a third party, and a change in position by the third party. We believe that under the guidelines of the federal standard, which involves that all inferences must be drawn in appellant's favor as the non-moving party, that the facts and circumstances of this case clearly establish all of those elements. And that's primarily based upon the significant testimony of Brandon Gilley, who was the representative of Gilley's Custom Homes. And more specifically, this has to do with the appearance that Gilley's Custom Homes created about its relationship with Terry Gilley. That deals, and we briefed this on Your Honor, obviously, is that the website specifically depicts Mr. Gilley, specifically identifies that it does concrete and decorative concrete work, which is what Mr. Gilley and Sean Pitcher had discussed and arranged for. And Mr. Gilley, Brandon Gilley, I know there's Terry Gilley and Brandon Gilley, so I'm referring to Brandon. Mr. Brandon Gilley specifically testified that not only did he know about the project, he ordered the materials for the project, he paid for the materials, he caused a notice to owner to be issued that specifically said it was under the order of Gilley's Custom Homes. So he was aware of the project, arranged for the materials, and paid for the materials, and only he could do that based upon his own testimony. So not only did Mr. Brandon Gilley know about the project, he participated in the project, and frankly, the notice to owner, which is a document that gets recorded in the public records to, create the presence of a lien or potential lienor who has a right to funds under the project, there was no disavowal by Brandon Gilley on behalf of Gilley Custom Homes that would separate itself from the project. And the reason
if I may, Mr. Kelsey, because I know the other side is taking the position that everything that you are saying right now, that really lends itself to a subjective feeling of your client, and then all the things, and then didn't also Brandon indicate, and let's use Brandon because Mr. Gilley, like he said, there's a lot of Gilleys. Didn't Brandon say that he was surprised and shocked, number one, that he wasn't aware of that? And then didn't he also testify that the website, that's not something that he put together, it was a third party that put together? And didn't he say that Terry was not authorized, that a card was used, it was not even his card, and just the invoices being written on scratched, it's not of its own. All of these things together, I know what you're saying, but all these other things that's out there, which then, is this something when you're in a summary judgment posture under the federal standard, is that enough to let it go to the jury, or is that enough for the court to say, hey, based on all of this concludes that was a more of a subjective, belief than an actual apparent agency?
Well, I think that's precisely the point of what we are raising in our brief and in our argument, that in addition to the facts that Your Honor just raised, there are a set of other facts that would establish the very issue that we're talking about, and that is the elements of the required for summary judgment. Your Honor quoted to me, and I've thoroughly reviewed the briefs, the appellee's position, but the appellee's position is actually incorrectly stated, because Brandon Gilley specifically testified that he knew of the project because Terry Gilley asked him to order the materials for the project. And under those circumstances, knowing that fact, the only way the materials could be ordered was for Brandon Gilley to approve them after he was asked by Terry Gilley to order them for the Pitcher project. I specifically asked Mr. Brandon Gilley in his deposition, did you know about the project before it happened, or did you contact Mr. Pitcher? He said, no, I didn't do those things because I knew it was for the Pitcher project, so why would I contact him? So to Your Honor's point, yes, there's one set of facts being argued by the appellee, but there's a whole separate set of other facts that were not even addressed by the trial court in its order. And in order to reconcile those two sets of facts, someone would have to weigh the evidence. Only thing the non-moving party had to do was present record evidence that would allow the trier of fact, ultimately, a reasonable trier of fact, ultimately, to reach an opposite conclusion. And because the standard is, as reasonable people may differ, you can't grant summary judgment. To ignore the set of facts that the appellant is putting forward would necessarily require the weighing of the evidence. So yes, we recognize the appellee's position that those things happen, but in order to get to that point, you'd have to discount the other facts that exist. And this was beyond mere, ignorance of what was going on. There was affirmative action here on behalf of Gilley's Custom Homes that put them right in the middle of this transaction, whether they wanted to or not. It kind of dovetails into the whole relationship between Brandon Gilley and Terry Gilley, as this was a small family-owned business, as they did share the same name, as Terry Gilley did rely upon Mr. Brandon Gilley to order the materials. This is not a fact pattern where Terry Gilley was just acting on his own to the exclusion of Gilley's Custom Homes. They overtly participated in this process. So from our standpoint, you can't just rely on the appellee's facts without also considering the appellant's facts. And under those circumstances, somebody would have to weigh the evidence to see who they believe. So under the circumstances, we believe that has to be a fact issue in order to coalesce the record so that there are a set of facts in front of the trial court to make a determination about what happened. And I don't want to underscore the point, well, I should say I do want to underscore the point that, without Brandon Gilley's involvement, this wouldn't have happened. And the notice to owner actually becomes exceedingly important because that's a representation to the general public about what Gilley Custom Homes relationship was. And while we recognize that disavowal of a relationship is not dispositive of any issue in the case, it is important evidence that creates an inference that a jury could conclude that, based upon what is being out there to the public, both in terms of a website, which is available for all of the public to look at, in conjunction with a formal document for Lenore, that those two representations are made to the general public. And in the context of how Mr. Pitcher arranged for the relationship between Terry Gilley and Gilley's Custom Homes, those factors clearly align into representations where a disavowal could have maybe clarified things, but created the inference based upon the record that the jury could conclude that it was a representation and then it was readily relied upon. I did want to just briefly address the trial court's order. The trial court ignored the very things that we have identified in our arguments, both in the initial brief and the reply brief, that the trial court never considered or argued or mentioned the notice to owner, the purchase of materials, those things that existed in the record and that were argued. And it's our position that in maintaining only the appellee's version of the facts, that the appellant was deprived of consideration of both of those points and both of those viewpoints. So I think that under the concept of, fairly established law that, agency issues and ratification issues are generally fact issues, there's enough in this record to clearly establish that there were two sides to the story, and that a third side would eventually emerge at the trial court, at the trial level, where a jury would have to draw facts and conclusions based upon the evidence presented, and that as a result, the appellant in this circumstance was deprived of that opportunity. I am happy to answer any questions that the panel has. Otherwise, I would reserve my time for rebuttal.
Thank you.
Thank you, counsel. All right. The time clock has been cleared, Mr. Muse. You are on mute, so you may want to change that before we start. And your time now will begin.
Thank you. Good morning to the panel, and may it please the court. My name is Bradley Muse, and I represent the appellee in this matter, Gilley's Custom Homes, Inc. In the course of my argument.
And Mr. Muse, I know I'm jumping right in because you've laid out in your brief all of that. But one of the things that Mr. Kelsky brought up, this notice to owner. How do you reconcile that notice to owner in terms of whether or not there is an apparent agency relationship? It's obviously, it was directed to your client. It's obviously indicated that they were somehow involved in this. And how do you reconcile that with your position that there was not any type of apparent agency relationship?
Well, several ways, Your Honor. First, as an initial matter, I'd point out that looking at the face of that notice to owner, it actually has to do with a completely different project. But that doesn't even really matter, because even assuming that it had to do with the driveway project at issue, it still does not create an issue of material fact here, because all that notice to owner does is says what really isn't in dispute anyways, which is that Gilley's Custom Homes purchased some of the materials that were used at Mr. Pitcher's residence. So, as far as the creation of an apparent agency, I would also point out that the notice to owner was not drafted by Gillies Custom Homes. It was not sent by Gillies Custom Homes. It's not signed by Gillies Custom Homes. So it's not a statement made by a principal, or the purported principal, which is required for an apparent agency in the first place. But also, as far as the creation of an apparent agency, that notice to owner was sent about 1 month after Mr. Pitcher had already remitted payment in full for the driveway project. So there could not have possibly been a reliance on that notice to owner, which is, again, one of the required elements of an apparent agency. There must have been a reliance on a statement and an action taken in reliance on that statement. But here, the notice to owner came a month after full payment had already been made. To the extent that it might go to Mr. Pitcher's other argument regarding ratification, it still doesn't get there. Because again, all that the notice to owner shows is that there were some materials purchased by Gillies Custom Homes that were used at the property. So not only does that not matter because it was not made by Gillies Custom Homes or sent by Gillies Custom Homes, it was sent automatically by the materials vendor, but it doesn't have any representation on there that Gillies Custom Homes intended to adopt the project as its own. It just shows.
And I guess one of the things, Mr. Muse, and following through with Mr. Kelsky has argued, stepping aside, what would be a reasonable thing? Okay, it's a family owned. Everybody has the same last name. And I know they talked about the website, and I know the website was created by someone else. And there's a picture of Terry right there. Then you have the added fact that they provided the concrete. They provided that. And granted, all the other stuff in terms of the direct communication only with Terry, the direct communication only with that. But with those facts alone, can't that a reasonable person would conclude, hey, they're all in this together. It's a family owned, he's ratifying all that. Isn't that something that could be reasonably be concluded?
No, it's not, Your Honor, for a number of different reasons. First of all, the statements made on Gillies Custom Homes' website, we're a small family-owned business. We do concrete work. None of that is an actual representation of authority that Terry Gilly or Gillies Custom Concrete has authority to enter into contracts or do work on behalf of Gillies Custom Homes, which, based on this court's decision in the Stolle versus Transitional Hospitals Corporation of Tampa case, when there's been no representation of authority by the principal that the purported agent has authority to act on behalf of the principal, then there isn't a sufficient statement for an apparent agency to exist. And not only that, but the statement has to show what the purported agent was expressly authorized to do. And the apparent agency is limited by that. So here we have statements that we're a small family-owned business and that we do concrete work. That doesn't mean that anyone with the last name Gilly who happens to do concrete work has the authority to enter into a contract on Gillies Custom Homes' behalf. And here the underlying claim was for a breach of contract against Gillies Custom Concrete. There's nothing on the website in the statements that we're a small family-owned business, that we do concrete work, nothing there to suggest that Terry Gilly has authority to contract on behalf of Gillies Custom Homes. And regarding the inclusion of his picture on there, a similar argument was actually raised in the case of Sarah Leguay versus Sucker, Zellman, Van Sant Paul, Biley, Hartman, and Waldman. And in that case, there was an attorney, employee of a firm, who the plaintiff claimed the attorney had the authority under a theory of apparent agency to bind the firm to a fraudulent transaction because the attorney appeared on the firm's website. In that case, there was even a biography written of the attorney on the firm's website, and the attorney was, in fact, a member and director of the firm. But there, the court stated that mere biographical information on a law firm website regarding a member of the firm does not constitute a representation that the law firm has authorized its member to enter into agreements on behalf of the firm. And there he was a director of the firm, and he was on the website, and there was a biography there. In our case, there was just an unmarked, unidentified picture of Terry Gilly working on a construction site. That is not any kind of representation that Terry Gilly or Gilly's Custom Concrete has any authority whatsoever to enter into a contract for a driveway on Gilly's Custom Homes' behalf. And regarding the purchase of the concrete, there are a couple of things there that I do want to address in terms of your question with, is this enough that a reasonable jury could find in favor? And we would say it's not, for a number of different reasons. Well, first of all, specifically regarding the jury question, here the record evidence contains evidence of Holmes purchasing only 1.5 cubic yards of concrete that were sent to Mr. Pitcher's property. And the total of that one invoice was $441.38. It cannot be the case, as counsel asserts, that a jury could reasonably find Holmes intended to be bound by concrete's contract and to be held fully responsible for a driveway that had a contract price of $33,500 based on that one sub $400 invoice for only 1.5 yards of concrete. And additionally, the purchase of the concrete itself doesn't really show any intent to be bound. It doesn't show a ratification by itself. Case law supports that conclusion, that as a matter of law, that is insufficient. In the case of Abuznade versus Searhall, a commercial tenant and his brother together reached out to the landlord and began negotiations to change the payment date of the rent. And the brother was even helping the commercial tenant try to negotiate a sale of the business. And then the brother went ahead and made a rent payment to the landlord on the tenant's behalf. When there was a default, the landlord tried suing the brother under the theory that he had ratified the subject lease. The Fourth District rejected that claim, stating that the brother's one-time payment of rent did not constitute sufficient evidence to establish his ratification of the lease. There wasn't enough there to show knowledge or an intent to be bound to the lease, even though the brother had paid rent on the lessee's behalf. And likewise, in the Sarah Leguay case mentioned before, the firm's disbursement of funds from its own trust account at the attorney's instruction did not constitute a ratification of the attorney's actions. In both of those cases, it was shown insufficient as a matter of law to establish a ratification. And that's based on the stand. Yes.
No, and while you're doing that, I want you to one other thing too. I want to make sure that that you have an opportunity to address that. One of the things that Mr. Kelsky indicated that Brandon, and I'm using first name, I don't mean that as disrespectful, just to make it easier, that Brandon indicated, I guess, in his statement that he was required to prove all accounts before payments were made, that he'd have to sign off payment to the supplier, and that he knew about the concrete pour. And while you're at it, Mr. Williams, I want you to address that as well.
Yes, Your Honor. So to that end, I would direct the court's attention to its own precedent, specifically cases like G&M Restaurants Corporation versus Tropical Music Service, Inc., and Stolle versus Transitional Hospitals Corporation of Tampa. In both of those cases, and amongst others, this court noted that for ratification to occur, the principal must have full knowledge of all material facts and circumstances. And then, after having that full knowledge, must then affirmatively manifest an intent to be bound by the actions of the purported principal. And here, the record evidence shows that Brandon Gilly knew two things about this project at the time the concrete was purchased. He knew that there was a job at Mr. Pitcher's residence and that the job required a concrete pour. Even assuming, let's say, he knew it was for a driveway, that still doesn't mean that that Gilly's Custom Homes knew the size or scope of the job, who Mr. Pitcher was. No representative of Gilly's Custom Homes had ever spoken to him before. Gilly's Custom Homes didn't know the budget of the job, what it entailed, what all supplies would be necessary. It just made a purchase of some concrete. How much concrete was going to be paid for the work? How much concrete and Terry Gilly were going to be paid? So that is far from having full knowledge of all material facts and circumstances, as would be required for there to be a ratification. And not only that, but turning to the other elements of the G&M Restaurants Corp. and Stolly cases, there has to be an affirmative intention to be bound, and there has to be an affirmative showing of that. And here, there's just no showing that Gilley's Custom Homes intended to be bound by Concrete's driveway project. Gilley's Custom Homes never received any profit whatsoever from the driveway project. And when Holmes learned of the project and Mr. Pitcher's claims about what Terry Gilley had represented, which didn't happen until after the lawsuit was filed, Holmes confronted Terry Gilley about it. And just the fact that Holmes made a purchase of some concrete from a vendor for Terry Gilley, it was paid back by Terry Gilley and Concrete for that order. So the facts here are really no different than a situation in which a subcontractor purchases materials for a project from a supplier, who that supplier then in turn gets the materials from a manufacturer. That does not establish the supplier's intent to be bound or a ratification of the job. That's simply the supplier providing some of the materials for the project in exchange for payment. And that's exactly what happened here. So the payment for the concrete itself, and whatever amount it was, even though here the record evidence only has the one invoice for about $400, here that is insufficient by itself to show that there was a ratification of the job. And case law supports that. The G&M Restaurants Corp. Case, the Stolly Court case, Abusney versus Sear Hall, Sarah Leguay, all of which show that the mere payment of some amount of money to a third party does not show a ratification. There has to be more. And here there wasn't any more than that. So as far as the actual creation of the apparent agency goes, here there are three elements that have to be established by Mr. Pitcher. The burden is on him to show that an apparent agency exists. And that comes from the Florida Supreme Court's case in Mobil Oil Corp. Versus Bransford. And there the court recognized three elements, all of which have to be met to create an apparent agency. First, there must be a representation by the purported principal. Second, there has to be a reliance on the representation by a third party. And then third, there has to be a change in position by the third party in reliance on the representation. If any one of those elements is not met, then an apparent agency is not created. But here, none of them were met. Turning to the first and third elements together, that being that there was no representation made by Holmes that Mr. Pitcher changed his position in reliance on. As noted, here the only representations that occurred prior to Mr. Pitcher entering into the contract and submitting payment in the amount of $33,500, the only representations that are cited to are the fact that Terry Gilley showed up with a mocked up business card that he hand wrote his own name on, saying, "I work for Gilley's Custom Homes," saying, "I work with my brother and nephew in the concrete division of Gilley's Custom Homes." And then Mr. Pitcher going on Holmes's website and seeing where it said a family owned business and seeing a picture of Terry Gilley. Well, as previously discussed, those statements, "we're a family-run business, we do concrete work," that's still not a representation of authority, which under the Stolly case from this court, that affirmative representation is necessary for the apparent agency. And just like in the Sarah Leguay case, the mere fact that there was a picture of Terry Gilley on the website, again, does not show that Terry Gilley had any authorization whatsoever to contract on behalf of Gilley's Custom Homes, or that he was even at that time working for Gilley's Custom Homes, which he wasn't. The undisputed record evidence shows that he was not an employee at that time. He did not have the authority to enter into contracts. He did not have the authority to send out business cards with Gilley's Custom Homes on there. So there was no active representation, no actual representation by Gilley's Custom Homes that Terry Gilley had any authority whatsoever to contract on its behalf. So already the claim of apparent agency fails. But I also want to point out that here Mr. Pitcher could not have reasonably relied on any representation that Holmes did make. So the remaining element of apparent agency requires that Mr. Pitcher have relied on a representation made by Holmes. And as pointed out by the 4th District in the Florida Power and Light Company versus McRoberts case, that reliance must have also been reasonable. In that case, it was unreasonable as a matter of law for the plaintiff to rely on his reading online that the purported agent he was negotiating with had a very high position with the purported principal. It was unreasonable to rely on that to reach the conclusion that the purported principal held the purported agent out as having the authority to enter into a contract on its behalf. And likewise here, it was unreasonable for Mr. Pitcher to have relied on Terry Gillies' picture and the statement that Holmes was a small family-owned business to form the belief that Terry Gillie and Concrete were agents of Holmes. The facts show that Mr. Pitcher communicated and negotiated directly and only with Terry Gillie via Terry Gillie's cell phone, which number was different than the phone number listed on Holmes's website that he said he went to. Terry Gillie told Mr. Pitcher to remit payment directly to him and not to Holmes. Terry Gillie was the only person that Mr. Pitcher ever spoke to. And there was even a contract handwritten by Terry Gillie and executed by Mr. Pitcher that did not have Holmes's name on it at all. Based on these circumstances, it would not have been reasonable as a matter of law for Mr. Pitcher to think he was dealing with Holmes. And this is not necessarily a jury question, as recognized by this court in the Jackson Hewitt Inc. versus Kaman case, in which this court affirmed a directed verdict, which under the new summary judgment rule has a similar standard to summary judgment. In that case, investors in a fraudulent scheme executed a contract that did not have the purported principal's name anywhere on it, and the investors made payment directly to the purported agent. Those facts are identical to the ones we have here. And in that case, this court held that under those circumstances, the investors simply could not have reasonably relied on any appearance or representations about the purported principal's involvement in the investment scheme. So is it here with the driveway. And in fact, the record shows that Mr. Pitcher did not rely on any representations. He saved Terry Gillie's number in his phone as Gillie Concrete. And after the driveway was done, Mr. Pitcher drafted a document to release himself of any potential construction lien related to the driveway project, purportedly in response to receiving the notice to owner. And on that document, Mr. Pitcher himself named Gillie's Custom Concrete as the only contractor for the driveway. Holmes is not listed on that document anywhere, even though he claims he drafted it in response to receiving the notice to owner. So not only were there no actionable representations by Holmes that Mr. Pitcher changed his position on, the representations he cites to, he clearly did not rely on and could not have reasonably relied on. So here, Mr. Pitcher fails to meet any of the elements of creation of an apparent agency, and also his claim of ratification based on the one-time purchase of some supplies for the material for the project also fails as a matter of law. And for those reasons, we respectfully request the court affirm the final summary judgment entered by the trial court. Unless there are any other questions, I thank you all very much for your time.
Odd to your timing skills at 1956, you terminated. That's pretty superb.
Thank you, Your Honor.
Didn't even have to interrupt and say anything. I appreciate that. All right, my notes here, clean the clock. Mr. Kelski, you have your 5 minutes remaining. You may begin.
Thank you, Your Honor. I think the presentation by the appellee essentially establishes the existence of fact issues in determining what is reasonable and what is unreasonable. The cases relied upon by the appellee, specifically FPL versus McRoberts and Jackson versus Hewitt, are completely distinguishable from the facts of these cases. In the FPL versus McRoberts case, that involved a high-ranking executive at FPL creating a multi-million-dollar deal at a FSU football tailgate party, and the FPL executive, in exchanging information with the person who relied upon the representation, specifically said, don't use my phone, don't call the office, make sure that no communication goes through FPL. And in Jackson versus Hewitt, which this court decided, there was a specific disavowal by Jackson Hewitt Inc. that it had no relationship with JH Investment Services Inc. So there was an express statement that we're not affiliated with that. The representation in this case goes beyond those situations. There's a website, there's photographs, there's a concrete division. They showed Terry Gilly. There was a business card, there was a small family business, and there was a purchase of materials. All of these things can't exist in a vacuum. They are facts that exist in the case. They are facts within the record. They are facts that are subject to different conclusions and different interpretations. And based upon the federal summary judgment law, those different interpretations, they reasonably lead to different inferences. And on that basis, summary judgment would not be appropriate. To try to address some of the other issues quickly, because I know I'm limited on time, you know, the notice to owner, again, specifically delineates that the order was created by Gillies Custom Homes. And it doesn't matter when it was provided, it just further shows ratification because it's in the public record. And absent a disavowal, it certainly lends credence to the ratification by the agent. At no time did, by the principal, excuse me, at no time did the principal say, it's not our problem, we didn't have anything to do with it. We did, and we did purchase materials, and that's conceded by the appellee. And, you know, maybe this is a problem with operating a small family business and doing things on behalf of other family members. Terry Gilly asked Brandon Gilly to order the project. Brandon Gilly said, I know that this is for the Pitcher project. I never called Mr. Pitcher and said, you know, it's not our doing, this is Terry Gilly's, you know, we're just helping him out. That's not what happened here. Brandon Gilly's control over the situation in ordering materials, paying for materials, had to be done, according to his own testimony, only by him and only with his approval. So he took the affirmative step of ordering materials. And the fact that it was maybe 1.5 yards of concrete doesn't lessen his involvement in the case, because even the notice to owner refers to concrete, rebar, and block. So I would point out that, you know, when we talk about the issue of having full knowledge and an affirmative action to ratify, that's precisely what happened here. And it doesn't matter that it was only a 1.5 yards of concrete. He actually purchased the materials for the project, so he knew about the project and participated in the project. The only other thing that I would like to address real quickly is the reliance on the Sarah, I hope I don't screw up this name, so I'm sorry, the Saraleghi matter. Although the representation was, there was a depiction of a partner on a website, the relationship was not with the law firm. The relationship ultimately resolved with the Mr. Doyle himself, who is the party that engaged in the fraudulent scheme. And the firm tried to separate itself as much as possible from that relationship, which is why there was no intention to be bound under those facts and circumstances. So it's clearly distinguishable in this case from the overarching facts that exist. So when we talk about a full knowledge and manifest intent to be bound, this court has determined that that is a fact issue, ratification. We believe that the agency issue, as well established case law, is a fact situation. We believe that there are two sets of facts, both identified by the appellee and by the appellant, and that the only way the trial court could have resolved those factual issues was to not consider the appellant's facts in this case, which is not at all a comment on the trial court, but a comment on the existence of the dual set of facts that require different inferences and different conclusions. And for that reason, we would request that the court reverse the summary judgment and allow this matter to proceed to trial on the disputed facts. So if you have any questions, I'm happy to answer them. If not, then I thank you for your time.
Don't see any questions?
None. Thank you both.
Thank you. Thank you both.
Your Honor, may I ask a quick question? Can we log off after we are done with our presentation, or do we require to stay?
I think you go back to the other spot, and there I think you're able to log off, but I need to couch that you should not rely on any of my representations. I have no technological skills whatsoever, and my panelists will verify that.
Judge
Thank you,
I'm the
Casanova.
one who can make things disappear on computers and things like that. So I'm really hesitant to do it. My little notes say you go back to the other room, the other spot. So,
Judge Casanova, I
Yes.
can confirm, Attorney Kelsey, all you need to do is just hit your leave button
there you go.
at the end of
Thank
your
you very
argument,
much.
and then you'll leave the argument. Yep.
Thank you very much.
Thank you. Thank you.
Thank
both.
you.
Thank you all.
We will turn to the last matter on our docket today.